Hello students, welcome to Sriram's IAS. Welcome to this class. We are going to discuss a very important topic today about the maternity benefits which are extended to women in India. Now, right to life and personal liberty, this is a fundamental right under Article 21 of the Constitution of India, has a myriad of rights inside it. Right to reproductive health, right to privacy, right to dignity, and so many rights are there inside it. And for that reason, courts are usually very liberal and harmonious when dealing with the reproductive rights of mothers. So in this particular judgment, you will see a unique case of Tamil Nadu, and usually the benefits, the maternity leave and other kind of benefits are extended to the first and the second child and usually discouraged thereafter for the third and the subsequent child. But in this particular case, the benefits are also extended to the third child. We are going to see why this particular thing has happened. So moving on, there was a judgment of the Supreme Court which has overturned the judgment of the Madras High Court, because this is a case of Madras. The women has approached the Madras High Court first. The Madras High Court has given a particular judgment which was overturned by the Supreme Court, and the third child was the benefits of the third child was extended to the women, and a harmonious interpretation has been done between the policy of birth control on one hand and the policy of maternity benefits on the other hand. Now, what is this particular unique case if you look? So, there was this woman and she got married in 2006, and as a result of this marriage, she gives birth to two children. Then, in 2012, after 6 years of the marriage and giving birth, she joins as a teacher. She joins, gets an employment in the state education department. She becomes a teacher in 2012, and unfortunately after 5 years in 2017 she divorces her husband. But after the divorce, the custody of the children has been given to the father. Now she has become a mother of two children, but she does not have the custody of the children, and she remarried again, and as a result of that remarriage, she again became pregnant and was about to give birth to a child, and she applies for maternity benefit. But the particular rule 101 of the maternity benefit in Tamil Nadu says that the maternity leave must not be extended to a woman who is giving birth to a third child. Now that was quite discriminatory, and for that particular reason, she approached the High Court. High Court does not favor her, and then she approached to the Supreme Court, which finally favored her, saying that the laudable, the laudable policy of family planning, of population control is important, but at the same time, the maternity benefits are also laudable. That's a very important judgment given by the Supreme Court. Now, if you see the maternity benefits, why they are aligned with the fundamental rights and human rights? Because of so many other rights which are related to it. The right of health, right of privacy, equality and dignity of women. Now, this particular act is there in India, the Maternity Benefits Act of 1961, and it has been amended in the year 2017. The benefits which are given to a woman under the 1961 Act were extended in the amendment made in 2017. So many more rights, or the scope of those rights has been extended in 2017. So if you see what happened in the amendment and what does this act say, is that if there is a woman and she is working in any particular organization and she has worked there for about 80 days in the 12 months period, then she becomes eligible for all kind of benefit, maternity benefit, before the birth of the child and after the birth of the child. The salary which has to be paid to the women should be full, shall not be cut. There shall not be any kind of discrimination. And she also gets leave. Now, a 26-week paid leave is given to a woman who is pregnant. Okay, she can apply for leave 8 months before the childbirth, and 8 weeks, this is not months, 8 weeks, 26-week paid leave is given. She can apply for this particular leave 8 weeks before the delivery, and the remaining 18 weeks leave can be taken after the delivery. Okay. Now see, this happens for the first and the second child. What happens for the third and the subsequent child? The 26 weeks paid leave is reduced to 12 weeks paid leave. Why these kind of discriminations are there for the third child? Because we follow a policy in India, those policy of family planning, which is based on the health policy of 2017 and the population policy of the year 2000. And for that reason, the government of India and the government of different states in India wants to discourage the population growth, and wants to arrest the population. There are many implications of this population growth. On one hand, it gives benefits, but on the other hand, it have so many drawbacks. And it is the policy of the government has been going on from a very long time. Now, special conditions and benefits which are given to a woman. Not only the woman who is going to give the childbirth, but what if there's a miscarriage? In the medical condition where there's a miscarriage, 6-week paid leave is given to the women to recover. Emotional recovery has to be there, physical recovery has to be there, and for that reason a 6-week paid leave is given in the matter of medical conditions. Adoption and surrogacy. What if the mother does not become a mother like physically, but after adoption or after using of IVF technology or surrogacy? In that condition also she becomes a mother, and for that reason she has to be given some kind of leave to take care of the child. And for that reason a 12-week paid leave is given to a woman, even in the case of adoption and surrogacy. These benefits are covered under the Maternity Benefits Act of 1961. Okay. Now it is the obligation of the employer that there shall be no discrimination against the women before or after the delivery. What kind of discrimination can be there? She can be given less number of days as leaves, or she can be given less amount of salary, or she can be asked to leave the company. No discrimination has to be there. Or there can be legal charges against the employer if the employer indulges in any kind of discrimination against the women. Full salary has to be paid to the women. Now, workplace supports. If you see, there are several workplace supports which are also the part of this particular benefit act, the Maternity Benefit Act of 1961. Work from home. New mothers can get work from home, and it's very much desirable to a woman because she has to look after her baby. A baby is quite small. It's a 20-year-old project. It's not something like it cannot be done in less amount of time. A baby needs too much of attention of a woman, of a mother, and for that reason work from home is necessary for new mothers, and this can be given. Then a crash facility is also available. Crash facility for any establishment which has 50 or more employees. There has to be a crash facility. Now, what is this crash facility? It is a facility where children are looked after when the parents are working. The mother is working, the father is working. Who is going to look after the children? So, in establishment where there are more than 50 workers or 50 workers or more than those workers, number of workers, a crash facility has to be there to look after the child when the parents are working. Okay, specifically when the mother is working. Now, if there is any kind of non-compliance, there are penalties on the employer. So they needs to be followed. Those laws, rules, regulations have to be followed. Now, what is the key takeaway from this particular judgment of the Supreme Court and from the Maternity Benefit Act of 1961? That these things, the rights are aligned with human rights. They are aligned with the right to life and personal liberty, Article 21 of the Constitution, and hence it's the fundamental right of a woman. Okay, so Supreme Court reinforces maternity leave as a fundamental right, and that is the reason why it has extended the benefits to the third child as well, because of the unique case of the women in this particular case. Future directions, it sets precedent for broader application of beneficial right. Supreme Court is always for this. Supreme Court has helped in the extension of the fundamental right to the greatest extent in India. And Article 21 is the example of it. Now, there are so many interpretations of Article number 21. If you see right to privacy, right to health, right to reproductive health, right to bodily integrity, right to clean environment, right against climate change, there are so many rights which are included under Article 21 of the Constitution, thanks to the interpretations made by the Supreme Court in this direction. And Judiciary is adapting laws to evolve the societal, because of the evolving societal needs and human rights. These progressive interpretations are made by the judiciary, and it will definitely have an impact on women. It will empower women. So, you know, the very important value of equality and dignity of women will be fulfilled by this particular judgment. It's going to empower women, promote gender equality in the workplace. Okay, so thank you very much for joining me in this particular video, and we are going to see you in the next video. Jai Hind.